In today's session, we'll be looking at what was meant to be how intellectual property rights operate in creative and entertainment industries. Apart from that, we will also look at intellectual property rights, the policy the Indian government has on it, and how teaching intellectual property rights could be significant, especially in the light of the government policy to promote intellectual property rights. So, what we plan to do this week is in this session is to cover how intellectual property operates in creative industries and also to look at IPR, the national policy on IPR, and teaching intellectual property rights as a subject in various institutes. And over the next week, we would like to keep it open for some general discussions and also look at case laws. Case laws are important because intellectual property right is predominantly a legal subject. And whenever a case is decided by the court, that crystallizes or it describes the law. To understand the law, it is important even for non-lawyers to be familiar with case laws. So over the next week, we'll be looking at some landmark cases affecting intellectual property rights. Like most of you might have heard about the Novartis case, which was decided recently by the Supreme Court. And there are other interesting cases as well. So we would look at case laws as a tool of learning, and we would also give you an heads up on how to look at case laws, because as non-lawyers, some of you may find it difficult to go through case laws. So we will look at that, and we will also summarize the key findings, and we will also prepare you for how you should be looking at case laws in the future. So they are legal documents written by judges, and there are quite a lot of pleadings that go into preparation of these case laws. But there are ways in which you can quickly traverse through a case law and understand its gist. So coming back to our subject matter today, so we are here to look at intellectual property in creative and entertainment industries. Now, creative industries are sectors that focus substantially on creating and exploiting intellectual property right products. Now, this could be with regard to movie making, it could be regard to music, it could be regard to books. And books is a big category in itself, because almost all the books that we purchase would come under the ambit of a creative industry. We are not only talking about works of fiction, but also works of non-fiction, and importantly, even books that cover education, say textbooks, could also come under this category. So, creation of textbooks is an inherently creative process, and especially in the light of what we saw at the DU photocopy case in the session on copyright, the question still remains there: how do you protect textbooks in this country? Because protection of textbook may not directly come out of the finding in that case. And how will textbook manufacturers invest in creation of these textbooks in such a way that their investment can be recouped? Now, going by the DU photocopy case, the court actually allows for copying of portions of textbook if it is for educational purposes. And soon after the case, there was some reshuffling, so to say, in the publishing industry, with some publishers actually pulling out or telling that they would soon be pulling out because it would not be feasible for them to get into or remain in this field. Because the moment you create a textbook and publish it, if the law allows people to make copies for educational purposes, because for a textbook, the educational institutions and the students are the primary market. So once you say that the primary market would have an exception to use it and to make copies, then the question that would arise is, how do you incentivize creation in this field? There are some models that have been proposed as to how you can make textbooks free and still make quite a lot of money in the process. But anyway, that will be beyond the scope of our discussion. But just to bring to your notice that when we talk about books, we are also looking at both non-fiction and fiction works. And more importantly, we also should be looking at how the creation of textbooks can also be protected in such a way that it can be incentivized. Now, the public sector may be interested in creating textbooks, say like the NCERT may produce some textbook, and they may even offer it on a open license. Now, that's something which we are not worried about, because there the textbook itself is funded by the government, the creation and the dissemination part of it. Most of the or all the lectures on NPTEL is again funded by the government. So the creation of intellectual property, when it is through publicly funded sources, then the further dissemination can also be controlled by the person who is in charge of creating them. But the more important point with regard to creation of textbook is, in the light of the DU photocopy case, Delhi University photocopy case, is how do you incentivize the private sector to come up with new business models such that we get new textbooks created, rather than relying on textbooks that are created in other places and copying them or using copies of them. The law also need to focus on how new textbooks in our country can be incentivized within the private sector. So creative industries, coming back to the point, covers music, books, films, games, but also sectors that focus on providing business to business creative services. Now, why do we need to protect these industries? Now, there is enough material to show that they make substantial contribution towards economic growth, and they are important for a knowledge-based economy. And especially in a country like ours, where the biggest strength is human capital, then the focus has to be on knowledge-based industries. Now, there are different ways in which you can protect creative industries, and there could be also different types of rights. And we had seen that copyright becomes the key form of right by which you could protect rights of the creative industry. Now, copyright is actually a right at one extreme of the spectrum. At the other extreme, you could say that you have works in the public domain, which means anybody can use those works without getting the consent or the permission of the creator. In between what is available in the public domain, and that's at one extreme, and the other extreme of copyright, you have various different kinds of arrangements, licensing arrangements like the Creative Commons, which would help both in monetizing the creative works as well as in allowing for a wider and a better dissemination. So if we look at creative industries at some point also overlap with cultural industries. So you can see the core copyright industries like press, literature, music, theater, operas can be protected by copyright. And you can also see software, database, and computer games, which could partially be protected by copyright, because some of the softwares are best protected by business model, innovative business models, rather than just by protecting the code. Almost all the apps that you know today, which you are using, say, let it be Uber or any of the other apps, they are protected by strong business models than by protecting the code itself. So, and you also have design protection for these works, and the subject matter could be something that is created by the private sector, and it could also be something that is created by communities. So, the creation would lead to production and manufacturing, then that could lead to dissemination and distribution, and finally to consumption. So, protection could extend to all these parts, and you will see the issue with creative industries is that at the point of consumption, there seems to be issues with regard to protection itself. And piracy, which you will see soon, is one of the issues that happens at the point of dissemination and consumption. Now, the global value of these industries have been, there are different accounts. They say that between 4 to 6.5% of the contribution to GDP is largely because of creative industries. And sometimes creative industries go beyond just books and films and music. It could also be design elements that you sometimes find in products. Say a shoe apparel company like Nike is predominantly a design company, and they are uh, the way they monetize their work is by designing cutting edge products which are produced in different parts of the world. Similarly, Apple could also be seen as a design and a marketing company. So this leads to rapid economic growth, and sometimes the economic growth could be attributed to the creative industries themselves. And it also creates employment, and employment in, as I said, in economies which are more centered on human capital. It could be a way for massive growth. Now, in India, media and entertainment are one of the fastest growing sectors, and we have the largest film producing market. And India is also the third biggest internet market with more than 500 million internet users. Now, the rights of creative industries would pertain to protection and exploitation of the right. Now, managing IP would involve what rights you own in your original work, identifying yourself as a creator and the right holder, then exploitation of the IP by licensing an agreement and by enforcement. Now, if you look at this, actually covers the creation till dissemination and exploitation of the work. Now, the rights can get affected at each one of these stages. There could be disputes with regard to the work itself as to who is the owner of the work. There could be issues with regard to exploitation when it is licensed, and also issues when it comes to enforcement. Now, the creative sectors include advertising, film and television, sports, music, publishing, where we can cover both academic and non-academic works, and fiction and non-fiction, and also video games. Usually, we have a copyright notice, and if you had seen YouTube videos, you can see copyright notice at the end for theatrical, musical, and artistic works. This is to show that the work is protected, and also that to show that the author owns the copyright. And the copyright, as we have already covered, the term of the copyright is life of the author plus 60 years. And copyright regime also allows for royalty payment for licensing the works. Now, copyright, some of the scholars have said, the copyright regime itself would be irrelevant when it comes to the internet. Now, there are reasons why they say this. Normally, if you need to copy somebody else's work, one way to do that is to quote portions of it and give a reference to it, attribute the source. And again, in traditional copyright, there are limits as to what you can show. For instance, you cannot quote an entire chapter of a book in your work, whereas you can only quote parts of it, and you may have to paraphrase it and give the proper reference. Now, internet brings in another dimension to this. Now, on the internet, there is no need for you to even produce or reproduce any other person's work. You can simply give a hyperlink to the work, and the entire work will be available for the person who is viewing it. So rather than giving a footnote, you could also give a hyperlink. And if the source that is hyperlinked is available as an open source, in the sense that it is freely available for a person who accesses it, then that would mean that the copyright regime in itself, which ordinarily protects people from making copies of a work, would be irrelevant, because the source can be hyperlinked and be made available to the viewer. So copyright has certain issues. Some scholars have said that it's time that the copyright laws are amended, especially when it comes to the internet. And there are also been new models of protection that have been advocated. And one of the things is with regard to digital rights management. Copies of digital works, which can easily be copied on the internet, and we had a case pertaining to peer-to-peer sharing, which is called the Napster case. Napster used to be a software tool that was used for peer-to-peer sharing of largely musical works. And at one point, there were 60 million Napster users. And that was largely illegal in the sense that the sharing happened without paying any royalty to the creator. But then law came around and they created digital management rights by various statutes and enactments, which largely did three things. One, there was a code in the file which made it difficult for people to copy. Two, it brought a restriction on the use itself. The time period within which you could use was restricted, and the number of devices on which you could use the copy of the file was also restricted. So, digital management rights evolved as a way to protect copying or peer to peer sharing on the internet, and that was seen as a need. Now, soon after the Napster, which was a website which allowed for a software which allowed for peer to peer sharing, soon after it was declared illegal, you had certain other forms coming up, business models coming up, which allowed for easy purchase of a audio file. For instance, the MP3 players were in vogue since the 1990s. There were different manufacturers who were manufacturing MP3 players, and MP3 players were one of the means by which you could easily copy and share files. But when Apple came up with its iPod, Apple also tied the gadget, which is iPod, and Apple was not the first person or the first company to come up with an MP3 player. They smartly tied it with their iTunes software, which allowed a person to buy a single track at an affordable price. Now, this was a remarkable change in the way in which the music business worked, because earlier the only way you could buy a musical work was by buying the entire album. So whether you wanted the entire thing or not, you had to buy the entire album. Now, Apple revolutionized the business process by allowing people to buy individual tracks, and they priced it at less than $1 as well. So Apple not only brought this entire range of musical works through a forum by which you could legally purchase it, it also combined it with a nicely designed gadget for consumption. So there was a business model which was largely iTunes allowing you to buy individual tracks at an affordable price, coupled with a sleek designed and nicely designed gadget. So this led to opening up a new market which was earlier not there. And before that, we had Napster, wherein we had 60 million users sharing files without paying any royalty. So we see a shift in the market. We also see a shift in the way in which law perceived digital rights management. They said that peer-to-peer copying will be allowed only in limited purposes. Say you had two gadgets, you want to make copies of it and retain that, or you could have backup copies, but it would not allow you to share it with others without paying the royalty. So this new model ensured that there was some kind of protection for digital works. Now, while this was happening, creative industries were also interested in protecting the term of copyright. So the term of copyright is largely fixed, but in some countries, especially in the United States, we see a tendency for the creative industries, especially Disney, to lobby with the government in such a way that they could extend the term of the copyright itself. Now, there is enough material to say that this was largely done to keep Mickey Mouse from falling into the public domain. And in the US, initially the copyright term used to be for 14 years, but then over a period of time, it became similar to what was in India, life of the author plus 50 or 60 years. Now it has reached a point where the copyright would extend up to 120 years from the date of creation. Now you can see this chart, and you'll see that the Sony Bono Act actually extended the right of creative works up to 120 years. And this is attributed to Disney's lobbying to protect Mickey Mouse, the copyright over Mickey Mouse. Now, creative works also could have an impact on how they are marketed. Now, marketing is a significant way in which creative industries can recoup their investment and also allow users to keep purchasing their goods. And intellectual property is instrumental in building the company's brand. Now, we have been seeing the role that copyright can play in the creative industries, but trademarks also play a significant role. In fact, any of the products that Apple comes out with, it's largely because of the brand value of the company and the fact that users attribute value to their product. There is some kind of a hype around the products. In fact, the same can be said for certain kinds of works of fiction, like say the Harry Potter series. And for one thing that's common for both Apple products and Harry Potter books is that people queue up before the product is released in long lines so that they could claim to be the first purchasers. So this is nothing to do, though they are all creative works. This has nothing to do with the copyright protection in itself. This is largely because of what the brands have grown to be. So the brand, both Harry Potter and Apple's products, they have grown to be attributed with a particular type of quality, and because the brands are protected all over the world, you can now see that they could be marketed in a smart way, in such a way that people have a following for it. Now, marketing could also result in others capitalizing on your marketing moves. Now, there is something called ambush marketing, where an advertiser ambushes an event to compete for exposure against competing advertisers. Now, every time there is a grand or a mega sale by one person, you could find others stepping in and capitalizing on that. Now, one of the best instances of ambush marketing in India happened a few years ago when the Cricket World Cup was conducted in India. For the event, Coca-Cola was successful in getting the official sponsorship. So Coca-Cola literally became the official drink of the Cricket World Cup. Pepsi lost out on the contract, but Pepsi came up with a smart campaign called Nothing Official About It. And they ran a campaign with different cricket players in such a way that they were largely seen as having a bigger impact than the official sponsor itself. So they ran a series of ads which with the campaign that Nothing Official About It, and that got quite a lot of traction for Pepsi. Now, soon after this, there were regulations that came in saying that the team players that are themselves bound by advertising only for the sponsors of the event, and they cannot do it for others who are not sponsors of the event. And we also found the logos, the name of the event itself being a proprietary thing. There were restrictions on their use. So even if a newspaper was covering an event, the newspaper had to get a license from the event organizer to use the name. Say it was the ICC World Cup or the FIFA World Cup. So they were all branded and protected words. So you could not do any kind of ambush marketing, and the event organizers themselves were willing to give this on a license. So here you have the ambush marketing between where Snapdeal uses Flipkart's greatest sale ever. And you can see that when Flipkart advertises for a sale, Snapdeal comes up by saying that for others it's a big day, for us it's not different. Just making use of the fact that there is a sale happening with a competitor by coming up with something as a parallel event. Now, creative industries also have issues with regard to licensing. Now, you could sell the authority for a third party to use the owner's right, and you could also stipulate certain conditions on the sale. Now, in IP licensing, recently we had the case where the tennis player Roger Federer disputed with Nike. Nike was the sponsor for Federer for a long time, and Nike also developed the RF logo along with Roger Federer. The dispute arose because Federer moved to a new sponsor this year for Wimbledon. He moved with a new sponsor, and he also made a statement that he should be entitled to use the logo RF. RF is actually an abbreviation of Federer's name, but RF logo was protected by trademark, and the trademark was owned by Nike itself. So sometimes when owners of the trademark may give up their right without knowing the consequences of it. So there is still a dispute pending, and Federer has made it clear that he would like to use the abbreviation of his name, but the law is in Nike's favor because Nike owns the abbreviation. Now, merchandising, as you had seen, especially in the case of Disney's works, is a way in which creative industries can protect their creative works. Now, merchandising would involve protection by way of trademarks and copyright, and that's one of the reasons why Disney had lobbied to extend the term of the copyright for Mickey Mouse, because it becomes more effective to protect these creative works by way of copyright and trademark. Now, creative industries are also protected by broadcasting rights. Broadcasting rights are also referred to as neighboring rights because they are rights that are that ancillary to copyright. So, the rights a broadcasting organization negotiates with a commercial concern. So, with regard to, mostly this could be with regard to a sporting event where it could be a sporting body, or it could be with regard to a motion picture where it have to negotiate with the film distributor. Now, sports itself is a billion-dollar industry, and we find that there have been issues with regard to what amount of sporting event can be, the information of sporting event can be disseminated. There were issues in our country with regard to whether live scores can be shared, and the event organizers claim that no live scores are proprietary material that is generated in the sport, and hence it should not be shared. Whereas news channels said that live scores of a live event amounts to hot news, and they said that that is something that should be covered by the freedom of press to disseminate news. So again, the key point to note here is that there is quite a lot of value that comes out of these industries, and there is a constant struggle to see how that value can be capitalized. Signal theft is another issue, and you would constantly see cable channels relaying certain numbers, and which is a way in which they can detect signal theft.